Part 2 of 41. The condition of the bond express fully his liability, and the delivery of the account may be enforced by an order of the surrogate and by an attachment to be issued by him, as in other cases of administration. All right. 46. By Chapter 71 of Laws of 1864, it is provided that every special administrator shall, within 10 days after receipt of money as such, deposit them with some person who shall give adequate security by a bond in a penalty to be fixed by the surrogate, with two sufficient sureties to be approved by him, and with such banking association as the surrogate shall direct. In the county of New York, he shall deposit such money in the incorporate trust company. These monies shall not be withdrawn except upon the order of the surrogate to be present to the dispository. And no order shall be made for such withdrawal except upon notice to the attorneys of all parties who have appeared in the estate. The special administrator shall be appointed only after notice of 2 days in writing shall have been given to the attorneys of the parties who have appealed in the case of the names of the persons who are proposed as sureties of the special administrators, and the time and place of their justification on the day fixed sureties may be fully examined, and if they shall not appear to be worthy collective, double the penalty of the bond. Letters shall issue. No sale or transfer of personal property shall be made by the special administrator except on the order of the surrogate, made on notice to all. 47. Tithes who have appeared by attorney. The time for the notice shall be then days, and shall be served on the attorney in the manner provided by law. For service of notice of motion in civil action, the time when service is by mail will require to be 20 days. The notice of application for a special administrator shall be given in the same manner at least 10 days before the application is made. Such administrator shall account for all interest received by him in the same manner as for principal. 48. General provision in regard to letters, testamentary, and administration, for what reason letters are revoked. 44. 2R.S.78, abbreviation 3R.S. 5th edition 162. In case of any one of several executors administrator to whom letters, testamentary, or the administration shall have been granted, shall die, become lunatic, convict, or infamous offense, or otherwise become incapable of executing the trust reposed in him, or in case that letters, testamentary, or administration shall be revoked or annual recording to law. With respect to any one executor or administrator, the remaining executors or administrators shall proceed to complete execution of the will or the administration according to law. If all such executors and administrators shall die or become incapable as aforesaid, or the power of the authority of all of them shall be revoking according to law, letters of administration or letters of administration with the will annexed as in the case required shall issue as in the first instant. If after granting any letters of administration on the ground of intestacy, any will shall be subsequently proved in letters testamentary or of administration with the will annexed, be thereupon issue and revocation of such first letters of administration shall be made by the surrogate, and until the same be made by the serve of such first administrator, his act done in good faith shall be valid. 25 S.L. 1837, Chapter 496, L.L. 1862, Chapter 229, 3 R.S. 5th edition, 163. When any person interested in the estate of the deceased shall discover that the sureties of any executive administrators are becoming insolvent, that they have removed and are about to remove from this state, or that for any other cause they are insufficient, as when the estate is discovered to be larger than at first supposed, such person may make application to surrogate who granted the letters testamentary or of administration for relief. If the surrogate shall receive satisfactory evidence that the matter requires investigation, B shall issue a citation to such executor or administrator requiring him to here appear before such surrogate at the time and place to be therein specified, to show causes why he should not give further certities or be supersede in administration, which citation shall be served personally on the executor or administrator at least 6 days before the return day thereof. Or if he shall have abscond or cannot be found, it may be served by leaving a copy at his last place of residence. The executor, administrator, or guardian cited to show cause why he should not be superseded may also be enjoined by the surrogate from further action until the matter is controversy shall have been settled. S.L. S.L. 1837, 535. If on the return day of the hearing of the proofs and allegations of the parties, the surrogate shall decide that the sureties or for any cause is sufficient, he will order the executor and administrator to give further sureties within 5 days, and if he neglect to comply with the order, his letters will be revoked. S.L. 1837, Chapter 460, S.L. 1862, Chapter 229, 3 R.S. 5th edition, 163. Where the petitioner swears to the interest, the surrogate will not try an issue upon the question. Easton W.M. Merchant, 1 Tucker 17. When either or all the sureties of any executive administrator shall desire to be released from responsibilities on account of the future acts of the default of such administrators, they make application to the surrogate who granted letters of the administration for relief, who will thereupon 30 issue a citation to the executive administrator to appear before him and give new sureties in the usual form within not less than 6 days. Okay.